Hello and welcome for part 2 of our 3-episode mini webcast here with Nicole Buncher, Senior Associate at Clifford Chance. Nicole, still some energy?
Yeah, loads, ready to
Let's go. What we have decided to tackle is, in light of the Middle East becoming such a wealth structuring hub and having now the tools and solution to wealth protect, legacy plan, etc., we thought we would tackle what every advisor and family should know in terms of preventing dispute. And who better than Nicole for that, since she's a dispute lawyer and a pre-dispute advisor in her day-to-day job. So I want to shift gear now after our first episode to what tools and where. And I appreciate there are many schools of thought. So perhaps if I can let you kick off, and then I'll probably have some questions.
Yeah, so I think really the key here is when you're looking at where in particular to structure foundations, you've obviously got a lot of the technical criteria that's relevant, but you need to make sure that the choice is being made in a way that's going to strengthen the structure and reduce future disputes. So you've got a lot of options, right? You've got the DIC, you've got ADGM, you've got RAC ICC over here, and then you've got like Jersey, Guernsey, Cayman, and BVI further afield. And so the question isn't just where to set up, but how to align the legal and cultural pieces so that the structure genuinely serves the family. And so ultimately, advisors are going to need to balance the really hard legal and tax analysis with the softer realities, such as like reputation, enforceability, and like the acceptance of the family. So a structure can be technically perfect, but if the family or the banks don't trust it, it's really not going to last.
So we have our thesis I made at MHQ. I'll touch on that in a minute. But from your perspective, being an international dispute lawyer, what's the first thing you feel that advisors should look at when comparing and considering jurisdiction for asset protection, wealth management, wealth planning?
So to start with, I'd look at reputation and credibility, because that's really, really going to shape how the foundation is going to be viewed by banks, regulators, and even the family members themselves. So jurisdictions like the DISC and the ADGM have built a really strong reputation over the last decade as credible, well-regulated centres that are able to blend the civil and common law principles. Jersey and Guernsey also, they bring decades of experience in trusts and foundations, and they're also trusted globally for their like contested jurisprudence. And Cayman's also become really well known for its privacy and flexibility, while Switzerland, for example, appeals to families who might prefer a sort of civil law environment with predictability and conservative governance.
And we outline here, MHQ thesis is that families are driven to high regulation jurisdiction out of which they can operate in a preferably unsupervised manner in a very private environment and to be able to keep control, which is something you can do in a non-tax jurisdiction. The UAE ticks all these boxes easy. And interestingly, it's also the rating as a financial center that has risen incredibly. Dubai and Abu Dhabi are today 2 of the 13 global financial centers in the world. That was not the case in 2011. 2011, 2012, you saw Jersey there instead of Abu Dhabi. So you clearly see a shift because people are more mobile, because the emerging superpowers are building equal, if not better, tools, and that are slowly competing with, if not beating, traditional wealth management center. And I see that every day. People sometimes need to be educated about reputation. They do not necessarily know about this. So what is the view of the clients that come to your very fancy office next to ours?
Yeah, I think reputation and recognition matter, to be honest, just as much as the black letter law.
Yep.
So you can have a foundation that's beautifully drafted, but if the banks and the regulators and the families are going to hesitate to recognize the jurisdiction, then that's going to completely paralyze operations. So a perceived lack of credibility or regulatory substance can also make it much harder to move or invest assets internationally.
Yep.
And so also in that context, you're going to have to look at the legal system and the predictability, whether it's going to be rooted in common or civil law, and how mature the case law is and how disputes are ultimately going to be handled. So as I mentioned, Jersey, Cayman, they have really deep common law roots and decades of fiduciary case law. And so with that, they've got predictability. Advisors know how their courts tend to approach issues like fiduciary duty or disclosure.
Yep.
And by contrast, places like the DIFC, ADGM, RAC, they're newer entrants here. So their legislation and their courts are really robust with internationally respected judges, modern procedures, but the body of precedent is still developing. And from my perspective anyway, that's definitely not a weakness. In some ways, I actually think it allows maybe more of a modern, flexible approach in thinking. But the one potential or perceived downside is that outcomes are less road tested than in the older offshore courts. And then you've got civil law jurisdictions like Switzerland or Liechtenstein, and they can work equally well, but they rely less on precedent and more on codified discretion. And so that affects how much interpretive flexibility a judge has if things go wrong.
And I'll second that by, I'm Swiss, and I trust common law courts more than Swiss court on what? Swiss court ruling on trust, I think is very alien to them. Common law courts like we have here in the DIFC and ADGM, I think it's much easier for them to rule on a fiduciary structure like a foundation, which embeds most of the principle of a trust and fiduciary duties, etc. So that's why I think that what we have built here has substantial legs, and you can see it this year alone, 2025, 700 foundation registered. This is a mainstream product now that has the trust of not only the local market, but also the rooted regional and supra-regional market, and eventually the super sophisticated international. And that is new, and that's why these people are drawn to the UAE equally for elements like privacy and stability. And I'll touch on that in a minute. I'll come back to another topic, but I just wanted to show this slide here. When you talk about credibility of the jurisdiction, you talk about perceived stability. According to the Global Financial Center Index 38, which just came out, it was Christmas before December, Dubai is today more stable than Frankfurt, Tokyo, and Zurich, not let alone Geneva and Washington, Boston. So how times have changed, huh?
Yeah. I mean, sort of regulatory environment and everything, and how intrusive or light touch all the authorities are going to be, and the degree of sort of regulatory scrutiny and privacy, it all varies very widely, but it's really, really important. And I guess that kind of builds into another topic in terms of actually privacy itself. Because actually that varies a lot. Some registers, such as in Jersey and Guernsey, they keep the foundation charter public, but the bylaws are private. And the DIFC and ADGM are moving towards more of a structured filing approach, but remain comparatively private, whereas Switzerland has greater oversight through its civil law administration process. And I really think advisors are going to need to sort of calibrate that and those nuances into the discussions with the family when they're managing their expectations, because too much opacity can look quite suspicious in today's compliance-driven world, but likewise, too much disclosure is going to feel pretty invasive for some families who value discretion.
Yeah, I second that, and I think the UAE is doing a great job at balancing this by saying we do not want the data to be in the public domain for those that do not want it, but we want everything compliance-wise like a bank would. And I think that's perfectly fair. And if you demonstrate to families that you have an infrastructure to protect that data, then you win. And you can do that when you are a commercially savvy, forward-thinking, but also economically strong country, as opposed to some sort of banana republic somewhere in the Cook Islands or wherever.
Yeah.
Okay, very good. We talked about privacy and
Yeah.
the two regimes that the ADGM and the AFC have, and actually Russell Gamma is even more private since the registrar is not even accessible. We talked about stability, and I know you had a few thoughts on that. Can you expand?
Yeah, so I think political and also reputational
Yep,
stability
yep, yep,
is quite key, and kind of perception with regards to adherence to the rule of law and participation in international standards like OECD make a really big difference to how jurisdictions are perceived.
yes,
And jurisdiction standing really directly affects whether international counterparties and financial institutions are going to work comfortably with the structure that's being set up. So, in other words, I guess stability equals bankability. And I guess from a sort of final perspective and the bigger picture points, the tax and treaty environment. So the foundation might be tax neutral, but if the founder, beneficiaries, or assets are in higher tax jurisdictions, double tax treaties and information exchange arrangements are going to have to be considered to determine how effective the structure is going to be in practice.
yep. So let's shift gear and move from macro to micro and to some practical micro level consideration. You touched before about reputation, which has an impact on recognition by counterparties, particularly banks. Today, we know that DIFC and ADGM, Russell Gamma investment and instruments are perfectly well recognized by tier one banks in global financial center. That box is ticked. What are the other micro level issues that advisors should assess and consider in your view?
Yeah, so I think the most obvious one is the assets themselves and the
Yep.
transferability.
Yep.
So what actually is going to be transferred and where is it located? That can quite often make or break a plan. So you've got some assets, for example, particularly UAE real estate, and there are
Yep.
restrictions there on foreign ownership, or they might require a locally licensed entity. So that basically means that not every foundation is going to be able to hold them directly. So the
Yep.
structure might have to be tailored around the asset, not the other way around.
Yeah.
You've really got to look at the beneficiaries' rights and enforcement. That's where I see a lot of disputes begin. So, in that sense, I would say really advisors should be asking whether the beneficiaries are named, are they grouped together, or are they purely discretionary? And
Yes.
how future beneficiaries going to be identified, and what remedies are going to exist if they become unhappy. So in practice, places like Jersey and Guernsey lean towards a trust style approach with
Yep.
clear disclosure and court supervision, whereas the DIFC and the ADGM might be seen to take a more flexible approach. Yeah, so they allow the charter or bylaws to actually provide for arbitration rather than court proceedings, which can be a pretty useful tool for confidentiality. And the recent updates in the DIFC and RAC have actually strengthened that arbitration-friendly stance, making it pretty easy to resolve internal disputes privately and efficiently.
Yeah. So the enforcement culture, in a way, is just as much important as what is written in the law, right? So it's the approach that matters. Yeah?
Yeah, I completely agree. It's not just what the statute says, it's how the courts and how the regulators are going to interpret that and how accessible interventionists they might be in practice. And then I guess you've got to sort of move to like governance and amendment powers and issues. So again, a lot of disputes I see start when later generations try to reinterpret what the founder's intention was, or they might try and sort of reimagine the foundation's purpose. Like some jurisdictions require founder or court consent for such changes, but others are going to allow the council a bit more discretion there. And so clarity on who holds those powers and when they expire is going to be pretty key later on.
You touched about the DFC and the RAC having recently refreshed their regulation. One of the key items was a reinforcement of rules on asset protection. Can you elaborate on that and what the clients should be aware of about these key features, which are remarkable for a global financial center?
Yeah, so asset protection is pretty key, right? That's always going to be forefront of clients' minds. And I think this is where advisors really need to be quite realistic. So most modern foundation and trust laws now come with firewall provisions. And
Yep.
these are basically just like statutory shields that are designed to block foreign judgments or heirship claims that are otherwise going to reach into the structure. And so the DIFC framework, I think, is a really good example. Its law sets pretty clear limits on recognizing foreign orders that are going to conflict with its own foundation legislation and
Yes.
really reinforce the principle that questions of validity and administration are going to be decided exclusively under the local law and by the DIFC courts.
Yeah.
But even the strongest firewall has some limits.
Yeah.
So a firewall won't necessarily save a transfer that was made in fraud of creditors or in circumstances of insolvency. In practice, though, the legislation in both like DIFC and RAC is going to limit a creditor's recovery to the value of the tainted transfer itself, rather than exposing the foundation's wider assets. And I think it's also just in this context worth remembering that a firewall is only as strong as the reach of the jurisdiction that created it. So if
Yes.
the foundation's assets sit outside its home jurisdiction, a judgment creditor might try and enforce it in the place where those assets are. So it's essential to know where the assets are and to assess whether they're exposed to potential claims. So ultimately, sound structuring, clear documentation, and really prudent solvency testing at the point of
Yep.
transfer are going to be the most reliable safeguards. And that's where a lot of future disputes and litigation tends to start.
Very valid advice. One thing that we see in practice is access to information, and for those people that are in controlling position is accountability. Can you touch a little bit on that, on the difference that can be made from tool to tool and from jurisdiction to jurisdiction?
Yeah, I see that a lot. So it's another tension point. Families frequently litigate because they feel shut out or uninformed. And so advisors really need to check just sort of basic things like
Yep.
whether annual accounts or management reports are actually required. And then secondly, who's entitled to see them. So you have things like bylaws, which might be private in one jurisdiction, but publicly filed in another. And
Yes.
privacy expectations are really going to differ between, say, Cayman and Switzerland. And then you're going to have to really think quite carefully about fiduciary duties and any
Mhm.
indemnities. So council members are typically going to want to be protected, whereas
Yep.
beneficiaries are really going to want accountability. So then you have like the default standards of care, which are going to vary as well
Yes.
within various jurisdictions. Some laws impose statutory fiduciary duties, while others allow exclusion clauses, provided there's no gross negligence or bad
Yeah.
faith.
Yeah.
And so advisors really need to make sure that those definitions are properly understood and documented and communicate them to the beneficiaries and the family themselves so they all understand and have a clear idea of what's what, because they're actually going to determine later on how defensible the foundation is going to be in the event of a dispute.
Impeccable. Hey, MHQ, Clifford Chance, you know what we are known for in the market? We give value. So let's give to the people what they want. If you had to leave advisors with a short checklist, what
Yeah.
would it be?
So the obvious thing, just stress test everything before you set it up. Are you absolutely clear who the client is? What do they want? Where are they and the beneficiaries located? Are you
Yep.
crystal clear on what all the assets are, where they're located? Are you clear in terms of which courts are going to hear any dispute? Do you have clarity on how local laws, things like Sharia, forced heirship, insolvency, are going to interact with the foundation? And finally, how a family expectation is going to play out once the founder steps back or passes away. And I really think once those questions are discussed and documented and understood by everybody, then the structure isn't just compliant, it's resilient and it's credible.
So in a nutshell, in very practical term, choose carefully, plan early, implement equally early, but keep communication open at all times, because if one of these elements is missing, the the continuity chain might be broken somewhere.
Yeah, I think that's right. And I think really choosing the right jurisdiction is less about prestige and more about compatibility, predictability, and family confidence. And if you get those elements right and the structure stands the test of time, then you've chosen well.
Very good.